All right, good evening and welcome everyone to the Tuesday, January 30 Board of Selectmen meeting. All selectmen are present, as is council and special counsel for Southborough. We're going to discuss the conservation restriction, and I think we have a few things to hopefully accomplish today. How the restriction should be held, meaning solo or co-held, and who would hold it. And then any edits that we may have from board members. In our last meeting and discussion, I recall a very lengthy discussion about who should hold it. There was information from the ad hoc committee that they would like it held by one entity called SVT. I believe there are many entities out there that do these things. But that was the one that they had zeroed in on. And then we received your guidance, Attorney Cipriano, that you thought it was in the best interest of the town that it be co-held by our Conservation Commission, as well as under the land foundation. It could be any number of land foundations out there. Many of us then attended a meeting that the Conservation Commission had. There was further discussion on the issue. They did not take a vote then. Subsequent to that, I understand they have taken a vote that they would rather not hold it. It's still incumbent upon this board as to what this board believes is in the best interest of the town. We had last given you guidance that we thought, based on your analysis and your legal opinion, that it would be best to have it co-held by the Conservation Commission and a land foundation. We did somewhat of a straw poll vote as to what we thought, and it was 4-1 to go with your opinion. And then, so tonight, I'd like to open it up, and Attorney Cipriano, Attorney Legere, welcome.
Thank you.
Let us know if things have changed since then, and what your opinion is as to the best way that parcel can be preserved.
And Mr. Chairman and board members, I did have occasion after your appearance before the Conservation Commission to further go before the Conservation Commission, I believe last week, and spoke with them at length and attempted, and I believe I answered all of their questions relative to the dynamics of co-holding versus a single holder. And I also came up with a different theory, which had been in a evolutionary way suggested by a planning board member, Mimi Luttrell, but we found that we could not reconvey to ourselves in the concept of what she was suggesting, but that third option would have been, or it is the ability of the selectmen, as you are holding it for the town, to give the care, custody, and control of the property with conditions to the Conservation Commission. I don't think they acted on that. They were more listening to the co-hold versus the single holder, and I think their vote was based upon that. But I will tell you again, this evening, I think I've attended probably 5, maybe 6 government meetings and issued 3 or 4 letters. Nothing has really changed in my viewpoint. My responsibility is to give the best advice to the town in how we can protect the town, not only now and in the future. It is clear to me that under state statute, Chapter 48C, the same statute that allows the town to have the Conservation Commission hold the Davis property, which is off of Breakneck Hill Road, that the best way to hold this is by our very qualified Conservation Commission in conjunction with a qualified land foundation. I have heard a variety of reasons, and they really are not reasons to me. They're more excuses why Concom shouldn't hold it. Suggesting that it's too complicated, it's going to be too costly, it's not done. The only good example is out of the Berkshires and Lennox, and I can tell you from my experience that the Executive Office of Environmental Affairs will permit a co-hold with a Conservation Commission, and the way I view this is such an innovative, creative, and absolutely precedent-setting land exchange that several members of the Board of Selectmen, together with the town administrator over the years, were able to effectuate not with any of my legal advice, but only putting it into legal form after the fact. Viewing that very unprecedented analysis and land exchange, my position would be that we should not try to fit the conservation restriction for the town of Southborough into existing models. This is the new standard. And on the basis of being a new standard, then whatever we decide will be utilized in the future for a similar situation. Now, having said that, relative to the co-hold, the other issue is a one holder or a single holder grantee being a qualified land foundation. I can tell you also that there's no legal impediment to doing that. I want to make that perfectly clear, that that is an alternative. Whatever your land foundation you decide, that is a viable alternative. We're going to be waiting as councils to see who the holders will be, because we will have to recraft the existing draft based upon all your comments of the CR, keeping in mind that this first draft came out from our office in June 2017, and time is moving along. But we'll listen to what your comments are, and then we would go back with whatever you direct us to do, and whoever's going to hold it, and recreate it into a legal form to be resubmitted. There's another component to this that I have not been involved with recently, but started with, and that's the plans, sketches, and designs of what needs to be part of a conservation restriction. The only thing that I was responsible for was the conveyancing ALTA plan, which is the perimeter survey, but it showed cleanly what we were acquiring. From that plan, all other sketches and plans will be created, envelopes and whatever needs to be done, including the cutout parcel, the division off of the public safety parcel. So those were the three alternatives I still see. The co-hold based upon our Conservation Commission, a single hold to any qualified land foundation, again, no legal impediment to that, that is legally sufficient to do, and this new innovative concept of care, custody, and control from the Selectmen to the Conservation Commission.
Okay, so with those options, the option you think best to protect that parcel would be a co-hold with our Conservation Commission and some other land foundation, correct?
That's correct, and then the language in a co-hold would be worked out, so there would be mediation language, there would be tie-breaking language to ensure that we mitigate or lessen to the best degree possible any controversy or dispute.
Okay, all right. Anything else before we open up for questions from the board members?
I would maybe just add one comment sort of following on that last point that town council made, which is that the preferred model at EEA currently for a conservation restriction that is co-held, so you have two holders, is to identify one of those two co-holders as essentially the primary grantee, and the other as the secondary grantee. And that is not necessarily a new thing. What is relatively new, in my experience anyways, is that the way EEA has been effectuating this, and this is true in a couple CRs that I've seen recently, and town council just mentioned a CR that was executed out in the Berkshires at the very end of 2017, where you did have the Conservation Commission for a municipality co-holding with a local land trust. These are structured now in such a way, and the way EEA wants it done, based on the conversations I've had with the folks in the Division of Conservation Services at EEA, is to have the secondary holder essentially have only the power of comment. So, in other words, the way it's structured is that if the property owner, if the grantor wants to do something that requires grantee permission, they put that request in writing to the grantees, just as they normally would have. Let's say there's a 90-day period for the grantees to act. In the first 45 days, the secondary holder would essentially come to a conclusion as to how that entity would like to see things handled, submits that determination, that opinion, to the grantor and the other grantee. But that's really all it is essentially the secondary grantee's 2 cents, their opinion, and ultimately that primary grantee has really full authority to take or leave that opinion, that recommendation, and do as the primary grantee sees fit. So, in other words, you have 2 grantees, but they're really not on equal footing. You have a secondary grantee, which really only has the power to suggest or recommend what it would like to see done, where permission is required, and that primary grantee ultimately has the ultimate decision, and really doesn't have to do more than just consider the recommendation of the secondary grantee. So I mention that only because it's a little different than the way things used to be structured. And I think it's important for the board to keep that in mind, where we have a situation like we do here, where you're trying to decide how you want this to be held with a co-holder or single holder. I think it's worthwhile to appreciate that what EEA is going to want, and as I understand it, what SVT, or probably really any land trust would want, would be that structure, and most likely the land trust being the primary grantee.
So, okay, so consistent, is that consistent with your understanding?
I actually, my first draft had a principal and a secondary holder, and then I equated them. I just made them equal. But the more that we discussed it, I realized, especially after council had indicated that to me, that that's the way the Executive Office of Environmental Affairs is working now. They want one principal and one secondary.
And so, and the secondary then would be, in this instance, if we went that route?
Well, you'd have to think about what you're giving for authority. The principal would have most authority, the secondary would have commentary powers.
That's right, and just in my experience, based on what I've seen in a situation like this, I would expect that any land trust who was going to be the co-holder would want to be the primary grantee. And that's the way it has been structured in the examples I've seen from EEA. If you have, say, a municipal board like a conservation commission with a land trust, it's the land trust that is the primary grantee that has sort of the more authority.
So if we were to do that, what benefit would it be to the town to have the Conservation Commission as secondary?
You would have the cooperative effect of getting both these parties to work together, both very qualified. In dealing with SVT, they're
Or
gonna
any land trust?
or any land trust, they're gonna be expecting a memorandum of understanding. So we'd have to start delineating the authority between the two. To me, that's really a government or administrative decision on whether or not the Concom should be the principal or the secondary. I would just make sure that whatever we can do to negotiate with whoever the land foundation is, that we ensure that we obtain as much authority as we can residually to the town via the Conservation Commission. And of course, you're still gonna be holding the underlying land on behalf of the town. So there could be sufficient protections that could be created under the tiebreaker issues, the mediation, and the memorandum of agreement that any land foundation would probably want to sign.
And how much work would you foresee a commission having to do over time on something like this? I mean, is it a daily effort? Is it once every 6 months something may come up, once a year? What kind of?
I'll take a crack. Certainly, I wouldn't expect it to be a daily or even weekly, or hopefully even not a monthly, situation that's producing work for the Conservation Commission. Typically, for a CR, you have essentially an annual review, more or less, where the grantee goes out to the property, makes sure everything is as it should be, makes sure that essentially the grantor is living up to the terms of the conservation restriction. Other than that, the only time anything is really required of the grantee is if something goes wrong. So if something happens out there that either is completely unanticipated and unexpected and out of the control of the grantor, if the grantor for some reason requires permission to do something, those are the situations where something would be required of the grantee, where the grantee would have to act. What we've tried to do in the way we've drafted this particular CR is to really minimize the likelihood of the grantor coming back to the grantee repeatedly throughout the course of the year by building into this sort of an annual meeting where the grantor, presumably working with the operator of the course, would essentially put together a report or a plan to say, here's what we see coming in the next 12 months, here's the work we really need to do in the next 12 months, give that to the grantee or grantees, they review it, everybody meets for a couple hours, talks through it, and hopefully that's the end of it. So ideally and typically, not a massive amount of work throughout the course of the year.
All right, you don't see it as a significant administrative burden on a commission?
I would hope not. You know, I think the only reason that this particular CR might be different, well, it certainly is different, and where you do have the active use of a golf course operating out there, I think there is an increased likelihood of a grantor, in this case the town/operator of the course, needing to go to the grantee for one reason or another. I do think there probably would be more of an administrative burden for this particular conservation restriction than you would typically expect.
And then in that case, is that part of your recommendation, Attorney Cipriano, as to why you think it would be beneficial to have the commission be a co-hold for those situations that do come up? Maybe they do come up once a year or every other
Yes,
year for something
yes,
that is
I would agree.
town property?
You know, you got what we have here, the unique nature, and I've said this before, is this property is doing three things for the town. It's creating, in a segregated fashion, a desperately needed public safety facility. It's preserving a local amenity, a golf course that's been there forever, for many years. But primarily, it's also protecting, which is what we all hoped for years, the open space that exists. So I think that interaction can occur. You've also got the town administrator on your behalf involved in terms of monitoring the management and maintenance agreement and ensuring that things get worked out. And at least in the brief experience I've had on some of these enforcements, the issues usually are violation of the conditions or encroachment. Well, there's going to be no encroachment. Our neighbors are the school, the public safety facility, DCR, and then the streets. So there's no encroachment issue by anybody that's contiguous to the property.
Okay. Other questions from the board members? Anyone want to start? Ms. Mr. Schiffer, please.
You mentioned in decision-making, how it would work between primary and secondary. If there was a violation or enforcement issue, would both have equal ability to pursue enforcement independently, or would that be part of the agreement?
Yeah, so the way that would typically be structured and the way I would anticipate structuring it here if there were co-holders was that it would be to identify, you know, essentially one of the grantees who would be the primary enforcement entity. And I would assume that would be the same primary grantee who, you know, would be primary grantee generally throughout the CR. If that entity, for whatever reason, does not properly undertake enforcement where it's necessary, the secondary grantee would have authority and power to do so. So in other words, and again, as town council mentioned, you'd have an MOU, sort of a side contract between the grantees, which would really pin this all down. But that's most often the way it's handled, is you have one of the two grantees who is sort of the primary or lead enforcement entity, with the secondary grantee having full authority if that primary grantee is not doing its job, if it falls down on the job.
Okay, thank you.
Ms. Fana?
Thank you again for all the information this evening. I'm sorry I was unable to attend the conservation meeting, but I did watch it at home. To me, it's unfortunate that we're entering into potentially an agreement between two parties, and we want to identify what could happen, what could possibly go wrong and be negative as a co-ownership of a piece of property. I've been involved in the Davis property. I was involved with the Beals property. I've sat at the table with Sudbury Valley trustees and many of the people in this room, and it was a very successful cooperative effort. And I'm hoping whoever or wherever this board what the board decides to do, we will continue that cooperative effort. And I know people in this room volunteer for Sudbury Valley. And I'm gonna go on the record, my family, my sister-in-law's family had donated a large tract of land in Westboro to Sudbury Valley trustees. I have no conflict, but I know people can work together. So I have no problem with this town being a co-holder. I think it's in the best interest of the community. They can call the Conservation Commission immediately. The staff at Sudbury Valley, I looked it up, I think they have 11 full-time members. I don't know how you call Sudbury Valley, have a complaint, how long it takes to get addressed, and who is on site if there is an issue. So I think it works both ways. I have faith in Sudbury Valley trustees, and I have faith in this Conservation Commission. We had Mrs. Russian in the past, Mrs. Levitt, Mr. Upjohn, Mr. Pessamano, and the team that we have today, we should all be very grateful. They're very detailed. And we've had that in the past. So I'm not as worried about Conservation Commissions changing. I think the expectation of conservation with the private citizens who pay taxes in this town, they appear before conservation, they get fined by conservation. I have faith in our conservation. And I also have faith in the partnership that conservation has with the Sudbury Valley trustees today in this town. So I'm in favor of a co-holder.
Thank you, Mrs. Faniff. Ms. Bracchio.
Thank you. I think everyone on this board has faith in conservation. I don't think it's a matter of not having faith in conservation. I was at the conservation meeting. I was able to hear the concerns that they had and why they voted the way that they did. When we appoint people to boards and committees, we ask a lot out of them. We ask them to donate their time, to donate their expertise, and to do the absolute best job that they can. And I took very much to heart what conservation said and the reasons why. I hesitate to go into any agreement with conservation issuing the vote that they did, 6-1. I have concerns. I do want conservation involved. I would like, Attorney Cipriano, if you could go into a little bit more detail for me, the care, control, and custody, how does that compare to a co-hold? Just to have an idea. I mean, basically, Attorney Laguerre has said that it's Concom would be just commenting. If it's just a commenting issue, is that covered under the care, control, and custody? And that's still respecting conservation. And at the meeting, a couple of the members said they would be open to hearing more about this. I just hate to go in when you have a board that's made their opinions very clear on their comfort level and request something more. That's just my opinion on that, but if you could just kind of give me a little more information on the care, custody, and control. Is it more than just commenting, or?
I'm gonna try to address that, because this is the whole thing is very innovative and creative, and it's an evolutionary process based upon what Ms. Luttrell said. And then I'm gonna let special counsel also address it, so you get the best advantage of both of us. But I think that what would happen here, you have to view it this way, that in effect, right now, the Board of Selectmen, as the chief executive of the town, have the responsibility of that parcel, because there's no other entity in the town that has any responsibility of control or duty. In effect, under conditions or terms that might be set forth between the Concom and the Board of Selectmen, in conjunction with the town administrator, for all intents and purposes, the Conservation Commission would step into the shoes of the responsibilities of the Board of Selectmen. And they would have the direct responsibility to deal with the single holder, whoever that land foundation may be. Luke and I had spoken about that. He is more knowledgeable about this concept. We both, with Conveyancing Council, just couldn't do a reconveyance. It just was not permissible as a matter of law. But this was something that looked like an alternative that at least we had to present, because it seemed viable.
Right, so yeah, that's exactly right. The idea of transferring this property sort of from the town of Southborough, held by the Selectmen, to the town of Southborough, held by the Concom, is just it just can't be done.
Yep.
Legally. So that is exactly why, in talking through this, it occurred to us that this was maybe sort of a middle road, and it's one that's not uncommon at all. More and more, where you see municipally owned land being put into a conservation restriction, it is the municipality by and through its conservation commission. So you effectively have almost two grantors. You have the town, and then you have the Conservation Commission. To answer the question that I think you had posed, which was essentially, is there a difference really between having the Conservation Commission take care, custody, and control of this property and then effectively become the grantor in the CR as opposed to the grantee? Would that be any different than the Concom being the secondary grantee? I don't know that it really would, frankly, because under the structure that I just outlined for you, that EEA now prefers, where you have this secondary grantee, which is effectively just advisory. That is what that entity will be doing, is offering its opinion, but ultimately that can, they could take or leave it. The primary grantee. You're flipping the Concom now from being sort of the secondary grantee to being the grantor itself. And so you're switching the roles a little bit. So I suppose the way that the Conservation Commission would be participating moving forward would be different. If, for instance, the entity that's operating the golf course needs to request permission from the grantee or grantees to do something or other. Well, now that request wouldn't be coming before the Conservation Commission anymore. It would almost be coming from the Conservation Commission rather than to the Concom. So the Concom, I think, would still certainly have an opportunity in that role to comment, right? If they are essentially the grantor making a request of the grantee, certainly I think there would be, I would hope anyways, a conversation there. The Conservation Commission would have an opportunity to weigh in as part of that request. And then ultimately the grantee, the land trust, makes the final decision. I think it's effectively the same thing if you have the Conservation Commission as the secondary grantee. A request comes to them, and the primary grantee, the Concom, puts in its 2 cents. Here's what we think makes sense to do here. And then the primary grantee, effectively takes that or leaves it and comes to its own conclusion as to what would be best. So I think in either role, the Conservation Commission would have a say, but ultimately they would not be the decision maker in either situation.
A follow-up question to that. I know when this was initially brought up, one of the things was it's almost transferring the property basically to, well, no, you can't conveyance to Concom. With the care, control, and custody, the town still owns the property and has control, or is Concom? I'm just trying to be clear on this method.
The town still holds
Okay.
any conveyance to a Conservation Commission in Massachusetts, the grantee clause says, to the town of such and such, under the, control or maintenance or by and through its Conservation Commission. And the reason for that is that the only legal entity is the municipal corporation body politic, the town of Southborough.
Yep.
And every agency is within the umbrella of that corporation.
Okay.
And I would just add briefly that municipalities obviously own a lot of land, properties that are used for many different purposes. And it happens very often that a town or city or town comes to own a parcel of land, obtains that property for the purpose of, or later decides that conservation purposes are the best use of that land. So maybe someone donates a gift of land that's essentially just 60 acres of wooded property. And the town looks at that and decides, this is prime conservation land. We can put some trails out there. We can allow passive recreation, hiking, dog walking, that sort of thing. So we want this to be conservation land. So we're going to transfer the care, custody, and control to our Conservation Commission. They essentially oversee it. If the Conservation Commission has any rules and regulations governing the use of conservation land, those will now apply. And that's effectively how it goes. And so really, this is essentially the same thing, just for this golf course property, which is maybe a little bit different than, say, wooded conservation land, but the same basic principle, where it would be the Conservation Commission sort of charged with overseeing that property. It's still owned by the town, though. It's still municipal land.
So the grantor would then become the town still, because the town owns it, or would the Concom become the grantor? That's the part that's confusing me. If the town owns it, you're giving some authority to the Concom, and I would imagine even if this was considered, the Selectmen wouldn't want to give all the authority for management contracts or anything with the golf or anything like that. So I'm just trying to be clear, the grantors, who is the grantor and their position on this?
The grantor, it goes right back to basic real estate law. The grantor remains the owner of record,
Okay,
which is the town of Southborough. And again, under the supervision and control of the Board of Selectmen, unless they take a different approach, which is what you're discussing. The only thing I'm not sure of is I don't know how Executive Office of Environmental Affairs, this is, again, very creative. I mean, this thing just spun, just like this whole land exchange, in a very innovative way. I don't know how EOEA would look at this.
I can only say that I'm familiar with a number of conservation restrictions where we have a situation just like the one we're talking about here, and EEA has signed off. The CRs are fully executed and recorded. So I don't expect that EEA would have any problem with the town doing what we're talking about now, essentially transferring care, custody, and control of the property to the Conservation Commission. You ultimately draft a CR, which now reads, the town of Southborough by and through its Conservation Commission. The selectmen have to sign any conservation restriction that's going to be touching land in Southborough. And so it might be here, you ultimately almost, and this is what I was saying before, I've seen it structured where you almost have two grantors. You don't, because you only have one owner of the property, but you'd have signatures from the Conservation Commission in addition, as sort of one grantor, and then the selectmen as well. So, it is something that has been done. I don't think it would be shocking or surprising at all to EEA to see the structure we're kicking around here now. I wouldn't anticipate any trouble with that.
okay. I mean, I know that you said that this is like groundbreaking, and believe me, I understand. I'm struggling to understand all of it myself to some degree. But, with how things are going in the future and things change all the time, I mean, this is innovative, and, seeing as conservation would still be involved in this way, I actually am very interested in this, and I guess, again, for me, it's comes down to if it's advisory in nature, co-hold, versus this. I'm still struggling to see if there's a big difference between the two. So, thank you.
Mr. Shea?
So, no questions that I have, and I thank you both for all the input that you've given us over the many meetings that you've had with us. I would say that my personal preference still remains towards conservation co-holding, but I think I find myself now in the same position as similar anyways, as Ms. Braccio, where, given the vote that the Concom took, and the magnitude of the vote, certainly respect the vote that they took. I just don't know that it's in the best interest to advance this as a co-hold CR. That said, there are other questions and comments that I did have throughout the remainder of the document, and before I made a final determination, I'd like to see how, those comments and questions are addressed that may impact, ultimately how I decide on a co-hold versus single hold. So, I think I don't know how you want to proceed at this
If you're not
point,
ready
but-
to vote on a co-hold or a sole hold, then I say we move on to the second piece and see
Yep.
see what you got, Mr. Shea. You want to lead us off?
Sure. So, I had gone through the draft earlier this month and forwarded my comments along to Mr. Purple, Mr. Cipriano. I think he's forwarded those to you as well. So, the first page, first comment, disregard that. that was a misinterpretation on my part. I had assumed that this version of the CR was modified after our initial meeting, and that it was going to be advanced based on our preliminary direction to revise the document so that it is a joint CR. So disregard that first comment about joint CR at this point.
The actual original draft in June
Yep,
was a joint,
okay.
and then your ad hoc committee modified it.
And this is a markup that I had on the version
Yep.
as presented to us by the ad hoc committee.
Right.
So the other one, just a general comment. So there's the potential that the golf course may change in name. It may become Southborough Golf Course, something other than St. Mark's Golf Course. This document refers to it throughout as St. Mark's Golf Course. Is there some legalese, some legal phrase, currently known as St. Mark's Golf Course, and successor names or something like that, just so if it does change, there isn't that conflict created in it.
Sure, that's an easy fix.
I think, yeah. Second page towards the bottom, we did acquire it in 2017. That's a change that needs to be made.
December 21st. I'll never forget the day.
Exactly. Towards the top of the third page, and this is just a minor comment. The second whereas statement, I don't know how that either adds to or detracts from the CR in general. I have no problem with leaving it there, but it just seems like there were just so many whereases that
Sort of
were going on.
is that the historic? So historic value is actually one of the values that would contribute to land being eligible for a conservation restriction. So that's,
All right.
we're sort of just laying the groundwork.
Yep, okay, good. So the 1, 2, 3, 4, 5, 6, I guess the sixth whereas paragraph on that page. And this may just be my writing style, but I found in probably 6 or 7 paragraphs throughout this document where we mention past or recreational opportunities and then continued to name them all. And I guess it would just be my preference, and not that I want to delete any of the ones that were proposed, but to identify one location where all those outdoor uses are defined, just so, as this goes through reviews, if people want to make edits and changes and, if someone thinks of another use that could come up with, now they have to go to 6 or 7 locations where you make that edit, as opposed to having that all in one location.
Sure, I get it.
I don't know if you know what I'm,
No, I think
trying
you
to
do.
get
I
at.
think it says, town council was just saying it's sort of a redundancy issue where we're sort of
Exactly.
saying the same thing
Exactly.
over and over again.
exactly.
Is this
So-
the one, Mr. Shea, where it says including? Is that what?
Well,
so-
exactly.
so-
So then,
You don't
page,
have to, once you start listing things, how far do you have to go?
Yeah.
By saying including, I guess you list a handful of them and
so
you
so
don't
page,
have to list every.
page 9, paragraph 6
Says
gives the
all.
definition for public access for passive outdoor recreation. And I would think that that would be the location where we identify all the uses. And then everywhere else, we just limit it to, outdoor passive recreational opportunities, which are ultimately defined by that paragraph later on in the document, just so there's no conflict
Just-
later on. If it's changed in one paragraph and not the other 5 or 6.
And just chiming in very quickly, my understanding is the whereases, and maybe this type of contract is a little bit different, but are not normally of great value in a contract. They're setting the stage, but the actual, meat of the document is always contained within the body of it, outside of the whereases.
They're like a preamble.
Yeah, that's right. I mean, I've always understood that whereas clauses aren't a binding part of a contract. It essentially just gives background, paints the picture.
Yep,
That's
okay.
it. Yeah, I think that's exactly right.
So, page 5, towards the top, again, the intent there was to delete the listing of the passive recreation uses and just keep that as later on. Ignore my note on page 6. Page 8, towards the top, I just included outdoor instead of passive. It seems like throughout the document, in some places, it's passive recreation, other places, it's outdoor recreation, outdoor passive recreation. I think if we can just be consistent in the terminology for that throughout, it'd be better. Again, page 9, that paragraph 6 in the middle of the page is where I think it'd be best to, I think you've gone into the more detail, or the most detail here to give examples of the outdoor recreation. I think they should all be bundled there. Page 10, I'll defer to you on this. There's a later paragraph. This is prohibited acts and uses, exceptions thereto, and permitted uses. One of the later paragraphs has the words reserved rights and in front of exceptions, so I don't know if that needs to carry forth there.
Let's make sure they see where that is.
I do.
Okay.
Page 11,
We're working, well, we got Mike,
Oh,
he's got
yeah.
his copy.
Yeah.
We'll be good.
Luke wants it.
We
I
do.
don't,
Well,
yeah,
he-
I'm
We have here.
cheating off it, yeah.
You got another copy?
Oh, perfect, thank you.
Page 11, paragraph 3, at the top, the second word. I don't know if that should have been filling instead of filing.
Yes, it should have.
Okay.
Good catch, thank you.
Page 13, paragraph 2. This is maybe covered the way it's written, but, you know, we talk a lot about the features at the golf course and where things are paved, not paved. We talk about the parking lot. I don't know if walkways to and from the clubhouse, whether that needs to be addressed, or if it's covered already, we can ignore that. So paragraph 3, I guess, is where I really get into the comments that'll impact, you know, how I ultimately vote on the holder, single holder versus co-holder. And this is the first example. And this all is under the section that has the reserved rights and exceptions to the otherwise prohibited acts and uses. Ultimately, these are the paragraphs that allow golf to continue on the parcel.
That's exactly right.
And throughout this section of the document, there's the words, with the prior written permission of the grantee, and those all refers to a number of things that would happen as part of golf course operations. And I guess it'd be my preference to change with prior written permission of the grantee to with prior written notification to the grantee. Personally, I think, and I don't know how others on the board feel, but I just think that the town, through its management contract, through its management agreement, is in charge of the golf course operations on that site. And I certainly think that it is wholly appropriate that the grantee, whoever it is, be notified of anything, of any work, anything that's going to be done as part of the golf course operations. But I think the town ought to be in the position of making the decision as to what actions are going to take place. And so it should be a notification to the grantee, not seeking permission of them to do that work. And I don't know if that, you think that that would raise issues with the state, with SVT, or is this?
I mean, I think it's going to, in some part, depend on exactly what we're talking about. So I think maybe certain aspects of this document, some of the paragraphs we're talking about here, we might be able to get around requiring actual permission from the grantee.
Yep.
Others, for more significant, substantial pieces of work, that's going to probably be a harder sell, not only to any prospective grantees, but to EEA as well. So in other words, I do believe that the town can retain the right to do work necessary to operate a golf course on this property without needing to go back to the grantee once a day or once a week. Hey, we're gonna go mow the lawn today, you know, is that okay? Hey, we need to water the fairways, is that all right? Hey, I need to put a little loam in the tee box, is that okay? I mean, these types of things obviously will be sure that the operator of the course can just do these things routinely without needing permission. Some of the larger stuff, if you're talking about major construction type work on the property, particularly if it's building or expanding structures out there, I don't think there's really a way to get around requiring grantee permission, approval of those types of things.
So theoretically then, if the town gives prior written notification to the grantee of work that needs to be done. SVT would then receive that notification, review it. If in their opinion it was something that violated the restriction, they would then have the opportunity to say, no, hold on, you can't do that, that's in violation.
That's correct.
So, you know, in that scenario, we wouldn't necessarily need to seek their permission to do it, but they would be acting in a reviewing capacity to determine whether or not it complies with the restriction, with this document.
Right, yeah, that's right. So in other words, the way this would be structured ultimately, and I think this is going to be true regardless of who the grantee is, and regardless whether it's a co-holder or a single holder, there are going to be certain things that can be done out there as of right. You don't need permission, you don't even need to notify anybody, you can just do this if you're the operator of the course. There are going to be other things. You know, the easy example that comes to mind is, again, building a structure out there of some sort in an area where you're outside of any of the envelopes we've carved out. You're going to need to get permission before you do that. And I don't think there's really a way around that for certain types of work.
That actually, from my perspective, makes great sense. I mean, no one's looking to build something, it's a golf course.
Right.
You don't want buildings
Exactly.
on it. You want open fairways and a tree to catch a ball every now and then. You don't want, you know, anything else other than a clubhouse. You know, and even on a 9-hole golf course, it's not as if you're putting, you know, on hole 4 or 5, you know, a restroom. You're not, I mean, so I think that makes sense. You wouldn't want that, you wouldn't need it, and I think from everything that we've heard from every member of this board, there's no intention of anyone to ever build anything on there. No one wants to. It wouldn't make sense. You're looking to have the clubhouse, and that's your structure. But I think Mr. Shea's point is very well taken. You know, we want to ensure that the town has the absolute ability to do those things necessary to maintain the premises, as it says, for use as a public golf course without having to get permission.
No doubt. And so I guess where we fall between those two extremes, mowing the fairway and building a structure, that's where there might be some spots in there that are a little bit of a gray area. And I think those are the areas where it's really going to come down to, frankly, essentially a negotiation with the grantee or grantees and EEA in the end to come up with allowable uses. Again, I'll just use the phrase as of right, things that can just be done out there without notification or permission, and those things that can't be done out there without notification and permission. And we'll just have to really work with those other parties to sort of define precisely what the limits of those types of work would be. Appreciating that, of course, from the town's perspective, you want to be absolutely certain that you're not prohibiting or requiring permission for basic maintenance type work that's going to really hamstring the operator of this course. And that's why when we met earlier this month, I had mentioned, and I think everybody was in agreement, that at some point here in this process, it's going to make sense for the operator to see this document and to make sure that we're not precluding anything that they absolutely need to do. I think that's not necessarily a party that has to be involved throughout the entire process, but I do think it's worthwhile at some point when we get a little further down the line here to have them review a draft, just to make sure we're not missing something.
And in terms of permission versus notification, we could also recraft language, and this is done normally in contracts, permission to not be unreasonably withheld. And that's the reasonableness standard. And that tells everybody that you've got to kind of work together, be practicable, understand what's going on out there and what's being requested, understand what your responsibility is, and get to a common ground.
Yeah, I mean, from my perspective, it would make sense that would be the fallback in the event that there was really that level of pushback where there had to be written permission requested to ensure that it's unreasonably withheld. But it wouldn't be the preferred method. I agree with Mr. Shea that we need to be able to do those things in the normal course of maintaining a golf course. And then finally, and we'll give just 1 second. So from your perspective, do you see that edit as proposed by Mr. Shea something that is more likely than not to be acceptable?
defer to you on that.
So, just give me a moment to see what we're talking about. I think that on paragraph 3, it may require a little bit of additional redrafting, but I think the types of work we're talking about there seem to me to be relatively minor in nature, and the type of thing that I think we could work out. Now, I obviously can't promise that, because ultimately, as I said, it's going to really be a negotiation. So, it's ultimately going to come down to the folks on the other side of this. But in my experience, and again, this is all sort of new, a CR covering a golf course is new, but based on what I've seen and heard so far in this process, I think that type of work, I think we might be able to at least, like I said, even if we have to tweak something else to kind of get a little more of a middle ground, I think we could maybe get out from under the absolute permission requirement there. Again, like the structures, maybe some of these we could get out from under, while others, maybe not. So maybe what we do there is just essentially break this up into a couple different paragraphs, or somehow just distinguish within this what would be allowed and what wouldn't. So, the short answer, I guess, is that I'm optimistic that we could revise this in a way that would give the town more flexibility and power to just go ahead and do some of these things without necessarily having to go get permission from the grantee. But again, that's something we'll have to work through with whoever the grantee or grantees ultimately are.
And again, it's not my intent to do this, behind, the grantee's back and
Oh, no,
without their
yeah.
knowledge at all. I think that we need to be upfront, and I think that they certainly have the ability to step in and, as the enforcers of the CR, the primary holders, to say, nope, time out.
Right.
That one we need to talk about before you do
That's
it.
right, and I think that's the important thing to keep in mind here, is that this is a collaborative effort. Right now, it's collaborative between all of us, the Golf Course CR Committee, everybody else in town who's given us their good thoughts and comments. The next stage of this is going to be collaboration with the grantee or grantees. Shortly after that, EEA is going to come into the fold, and they're going to be chiming in with their 2 cents. And that's, frankly, once EEA gets involved, it's maybe a little less of a collaboration and a little more of dealing with the government agency. So we can certainly push back a little bit on certain things, but in the end, we need them to sign off. So at any rate, it's just meant to say that this is, it's a work in progress, and we can certainly try to revise aspects of it to get the town more authority and power.
I'm presuming the concern is that we're gonna have this CR will probably be duly recorded before any of the work of reconstructing the golf course. If this is gonna go on on or before June 30th, or at least be filed well before that, you're going to be reconfiguring this golf course a year down the road? So this thing will be in effect. So you
Well,
can-
certainly, temporary greens and things like that are gonna have to be done immediately,
Okay.
to allow play for this year.
So you're concerned that this will be duly recorded, then you're gonna be doing that, or in conjunction with the filing, and then you wanna just ensure that you have a certain flexibility to do what everybody intended to do,
Yeah.
which is build a public safety facility, segregate it on a separate lot, and then reconfigure the golf course so that you now have your permanent open space and course.
Yep, and again, a part of it, my thinking as well is, with due respect to SVT or whoever the ultimate grantee may be, they're not in the golf course business now. And, I want the town and its management company making the golf course decisions. Obviously keeping SVT and the grantee fully apprised of the intentions, but, I think it's incumbent upon the town to, to run the golf course in a way that it is a successful operation.
And I think
They should be
that's.
the decision makers on that.
No,
That's my
I
point.
think that makes perfect sense, and that's, to my mind, yet another reason to bring the operator into the conversation, to help educate SVT or whoever the grantee ultimately is as to what really is required out there, so that the grantee, who's charged with enforcing this CR, appreciates and understands what really has to be done out there on a routine basis, and maybe, not a daily basis, but a regular basis, to be able to operate and maintain a golf course. And I think the better we're able to educate the grantees on those facts, the more reasonable their enforcement of this will be, and the more reasonable they'll be where requests are made that just make good sense, in line with what they've heard already.
I think along those lines, it's important to incorporate, at least in our first draft, the changes that Mr. Shea's proposing. And since it's going to be a negotiation, allow the grantee and the state to come back to us and tell us what isn't in a gray area and what needs to be on that restricted side. I don't want to go forward in our first draft with restrictions that may not be imposed. And it's going to be extremely challenging, even without a CR, for the operator to be successful there. And it's extremely important to us that they are. So the least amount of restrictions possible, I think, is extremely important, especially for the first couple of years.
Sure.
So,
Yeah, that makes sense, and my, what I imagine happening here as we move ahead is that this draft will be revised based on the comments that you've given so far and any others that you have, and you all will see at least one more version of this CR before it goes to anybody else. For exactly those reasons. We want to make sure that you all are comfortable with what's being presented here before it goes to other parties who are going to have their own changes and ideas.
And I would imagine as well, too, to add on to that point, if you're within the four corners of,
Mike, sorry.
I would imagine, too, if you're within the four corners of the basis of the CR and the restrictions on the CR, I agree with Mr. Shea, and you'd be hard-pressed to have to ask them if you could mow someplace that's already covered within the CR. So I totally agree with him on that point. And as far as the structures as well, as Mr. Kalenda said, I mean, obviously, they should have input in that as well. But I think those are very good points, Brian.
Mr. Shea.
All right, so I've already taken up more time than I had hoped, so. Page 14, just looked like there was a copy-paste
Yeah,
error
I
with the
apologize for
paragraph.
that.
No problem, no
Not sure
problem.
what happened there.
And you'll see that there are a number of other places where I had picked up on the permission of and recommend
Okay.
notification of. I don't think we need to harp on each one. Middle of page 18, paragraph 18, irrigation. My reason for making an edit here, I don't know, I hate the word minimize in agreement, and I don't know how that's, and it's subject to interpretation, so I just come up with a recommended rewrite to, just allow irrigation as necessary in accordance with sound golf course management practices. So you can consider that. Yep.
On page 15, 7, a man-made pond to serve as a water feature and provide water to irrigate. And what Brian just brought up, does that need to be clarified? Are they one and the same?
So not necessarily. The paragraph on page 15, that
They're
Ms. Faniff
creating
is referring.
something.
That's exactly right. So what we're doing here, through the course of our hearings with the Golf Course Committee, it was pointed out that for irrigation purposes, it would be really beneficial to actually have a pond on the course that could be used really solely for irrigation, but that doesn't exist currently.
Right.
And so really to allow for at least the possibility of that happening after this CR is in effect, we agreed that the best way to do that was to, within this envelope that we're already carving out to allow for certain uses that otherwise would be prohibited, to include that in there as well. So that's really meant to focus solely on the potential to create a pond for irrigation purposes.
But as of today, that has not been identified on a plan.
Right, that's right. That's right. We don't, this was just the area that we're talking about here. As we talked through it, we realized that actually made sense logically and topographically, that that's where a pond might go. So it was intended really just to allow for the possibility of that happening down the line. The paragraph on page 18, paragraph 18, is talking just about irrigation in general. So whether there's a pond or no pond,
It's not one or the other, that's what I'm trying to get at.
it's not one or the other. No, not at all.
We're
It's,
not gonna
there will
tie
be,
someone's hands that you will have this versus
no,
that
that's
in
right. There
future.
will be the right to irrigate, and all we've done in that prior paragraph is also create the right to essentially construct a pond.
A window for the opportunity.
Yeah, or an area where you could do that if you chose to do so.
So,
Mr. Shea?
Thank you, Brian.
just two more quick things. On paragraph 23, at this point, I don't have a better suggestion for that paragraph F regarding permanent abandonment of St. Mark's Golf Course, so I'm not gonna comment on that anymore.
Yeah, okay. I recall that came up
Yep.
in our last meeting, yes.
And the last I have on page 25, paragraph D on that page, seems to be a duplicate of a severability paragraph that's noted later on in the document on page 33. And I don't know if one should be deleted or if they both apply.
Yeah, I don't think we need them both. I think,
So if you could just,
Yeah,
whichever is
okay.
best for
yeah,
that.
I
And
think
those were-
the latter would probably be better to retain, so, okay.
Those were the substantive, again, the biggest point in this in my mind was the written notification to as opposed to permission of.
Sure.
So,
Any other comments on the draft? Ms. Brockie?
Thank you. I know I had given a couple that, actually, I think Mr. Shea had addressed, but as I was still going through it this afternoon, I came up with a couple other questions. On page 26, under costs, I believe it's yes, page 26, under costs. I would like to see, if possible, some type of reciprocal language in there, that in the event that there is a violation and it goes further than any of us had ever expected, that if we win, so to speak, in court, that we're giving the grantee the opportunity to come back for the town for fees if they win. I would like to also see the same reciprocal language put in for, I don't know if that's allowed, but it's something I'd like to consider.
Yeah, so I'm happy to look at that. This particular paragraph falls in the category of provisions that I think we've talked about before that are essentially just the boilerplate. EEA has its model CR. It doesn't like to see that revised.
Okay.
But I certainly take your point, and I'll see what I can find and do about
I mean,
that.
not that any of us anticipate there being any problems,
Sure.
but again,
No, I
this is-
understand. It's
This
a-
is forever, so
it's a-
at
it's
some
a
point.
check. It's a check, and it's, we can always try. Let's put it that way. I say that mainly just to warn you that this is one of the paragraphs that EEA really, really does not want touched.
Okay.
But with that said, it's not unheard of, and
Well, fair
you never know
enough.
if you don't ask.
If they don't, you know.
That's exactly right.
What I think that paragraph is trying to do is, I don't think it's trying to set up the potential of a conflict between grantor and grantee. I think it's saying, in effect, that if the grantee and their responsibilities is finding a violation by a third party, somebody's encroaching or whatever it might be, some third-party violator, and, you know, it's informed to the grantor, and the grantor, in effect, agrees that it's acknowledged by the grantor, and it's determined by a court of competent jurisdiction that all the grantee did was go out and protect the land as they're supposed to. You, as the grantor, agreed we did that, so based upon that, we're seeking reimbursement.
Okay.
I don't think
I,
that's setting up
I
a
read it
conflict.
differently, so
Yeah.
that's why
I-
you're sitting on that side of the table,
no, well,
and I'm asking the questions.
I
so-
understand perfectly where you're coming from, so like I said, let me just spend a little
it's
time with
just
it, and I'll see what I can come up with.
Something I'd like to throw out there. And on page 12, number 12, hunting and trapping, except as may be permitted by the grantee. I would also like to see some language that we have an input in that as well. I understand Beaver Dam, you know, who knows what it could be, something, again, down the road you don't know. But I'd like the grantor to be involved in that discussion as well. Whether it be through Concom in an advisory nature or however, I would just like to see some input in that. One final point, and then I will turn it over. On page 27, under the extinguishment clause, I understand why that has to be in there. I've kind of gone round and round on this. I found some language today in going through, Harvard Law came out with a great thing on conservation restrictions I actually read today. And I just want to make sure that the intent that I read on another website as well is potentially covered under this, that the extinguishment also requires the consent of the land trust. Is that, I couldn't seem to decipher it in here, and as I read it, it just seemed to be that it just automatically, the restriction goes to EOA and legislation, but I would assume, and I guess I'm asking the question, on the extinguishment clause, does it require the, what did I say here? The consent of the land trust as well as the town? Is that a joint extinguishment? Obviously, it would take something, a meteor strike, I mean, who knows? You know, I mean, I can't think of something that would cause the land to not be able to use for what it's used
Right.
by. But it just wasn't clear to me, and maybe I just missed it as I was reading through it, that the land trust also has to be involved in as far as the basis for the extinguishment.
So you're sort of reading this as saying essentially that EEA is the sole sort of decider.
Well, somebody's going to get to that point, that, again, something happens, and we are asking EEA and, you know, going down that road. I don't see how we got to the point. Was that determined by the town to do this? Was this a joint between the grantee and the grantor?
So, yeah, I think, yes, that, what you just said is, I believe, practically speaking, exactly what's contemplated and intended here.
Okay.
That in order to extinguish this.
Yep.
You would need essentially to have the grantor and grantee or grantees go to EEA and
Okay.
say essentially, this doesn't apply anymore. It just doesn't make
Perfect.
sense. A meteor hit the property.
Right.
You know, we need to do scientific research out there. We can't have a CR on here anymore. It just doesn't work.
Okay.
Yes, I think that's
Just
exactly.
wanted to make sure that the intent was there, as I've seen it in others, and in some and not in others. So I just wanted to make sure if the intent is there, then that's it for me. Thank you.
All right, any further questions on the document itself? Ms. Faniff, anything
No, I'm
from
all
you?
set.
Okay, nothing further? Okay. All right, so then I believe we are back to point number one, which, whether or not we believe it should be solely held or co-held. I will start off the discussion, I guess, and consistent with our last amount of guidance given to council at a prior meeting. It was 4-1. I'll make a motion that we move to have the conservation restriction co-held for discussion purposes. Is there a second? Seconded by Ms. Faniff. All right. Further discussion on council's guidance that it be co-held and our position.
A question of council. If we decide to have it co-held, we can also decide who would be the primary, is that what you said?
Yes, they could.
You could, I would say that you can, you could suggest who you would like to see as the primary. Ultimately, again, if EEA and/or the land trust that's going to be one of the two grantees doesn't agree, then you're stuck. So it's just not something that you can unilaterally decide. You can certainly make your preference clearly known, but, you know, again, ultimately, you're going to have a land trust that's agreeing with what you're proposing, and you're going to have EEA likewise agreeing that, yes, this is an acceptable arrangement in the state's view. So,
I accept that analysis, but this is town of Southborough land, and we would do everything in our authority to ensure that whatever you wanted in terms of this would be carried forth. This is gonna be a negotiation process with any land foundation, I'm sure. They're not gonna simply take our draft and simply say, it looks great to us, cut us a endowment check and we're off and running. So there's gonna be a negotiation in there somewhere, so you wanna get them on board. And then there are dynamics dealing with state agencies. Both Luke and I, in our experience, have done that. And, you know, we're gonna stand firm in representing the position of this board and this town to them and what we expect that they will do. And if there's pushback, we'll deal with it. And if it's significant pushback, we'll report it back.
Yeah.
All right, thank you for the clarification.
Other discussion? Ms. Bronchio?
Thank you. I still stand by my position that I believe that I have more comfort now with the care, control, and custody. Giving the care, control of custody to conservation, that conservation still will be involved, will still be able to comment as they would as a co-holder. So I just still firmly believe, for me, that's the way to go. Thank you.
All right, thank you. Any other discussion?
Yeah.
Mr. Schifrin?
I think it's important to note that the people that came to these meetings, our meetings that we held on it, Concom, the people that sent in letters that, at least in my mind, the voice has been heard. It didn't, however, change my opinion about the reliance on town council's opinion. I just think it's a unique situation and a special property, and we don't know the long-term ramifications of not following town council's advice. Frankly, we don't know the long-term ramifications of following town council's advice. But given the situation and the unknowns, at least in my mind, I feel more comfortable being on the side of following town council's advice in this scenario. And the idea of turning over the care, custody, and control to another board actually makes me feel more uncomfortable. I think that care, custody, and control of especially this property, but really any property of the town should be with this board. So that's just some of the reasoning behind how I'm going to vote.
Thank you, Mr. Schifrin. Any other comments before we vote? All right, seeing none. Motion's been made, seconded by Ms. Faniff. All in favor, say aye.
Aye.
Aye. Not in favor.
Aye.
All right, 3-2, Counselor. Okay, then that, and no further comments on the draft based on that guidance from anyone? Okay,
Could we just verify procedure going forward?
please.
And it would be, initially, that we will recraft this conservation restriction, consistent with what you've said. We will submit it to you, and I understand that your ad hoc committee remains in effect. And I understand also that they are suggesting that they're gonna meet weekly to further discuss things. I can understand that they may want to be able to discuss a further revised draft of what you have just instructed us to do and make further comment. But at some point very soon, we've got to start moving forward to finish in legal form, I have to get plans created with the engineers and the land surveyors, and we've got to start making interaction with the State Department to bring this forward to filing. So are we instructed to meet, continue to meet weekly with your ad hoc, or are we?
Not at,
What are we
from my
doing?
perspective, not at all. I'd like to hear from others. They think these gentlemen need to do the work that they need to do.
Yeah, I mean, I made the motion to continue that committee, and from my mind, what I wanted was that committee to have the ability to review and comment on the final document before we made a decision.
All right, anything else on that? All right, so,
Okay,
All
we
right.
understand our charge.
and then we do need to discuss, so we decided there would be a hold. And then, what options does the town have in terms of a land trust? In your experience, we've heard the one name of SVT. I believe there's also the Worcester Land Trust, the Worcester Land Foundation. What other ones are you
Well, there
aware
are a
of?
variety. In Worcester County, the one that we were able to find is an entity not around as long as SVT, but it's known as the Greater Worcester Land Trust. They, according to a search of the recorded records of Worcester Registry of Deeds, hold conservation restrictions in Holden, West Boylston, Worcester, several in Worcester, and Leominster. And they're also active in not only being the grantee of a conservation restriction, but they acquire land or get land gifted, and then they reconvey as a grantor to protect the land. So I know nothing about the track record of this entity. I think Luke was also attempting to look up and see other alternatives. I had heard generally about Greater Worcester years ago, but again, basically that's all I know about that entity. Although there's a variety of entities that have been accepted by the Executive Office of Environmental Affairs. At the same time, SVT is predominant.
Okay. Yes, oh, Ms. Fanick.
Sorry, I'm sorry, go ahead.
I have a question. Are we required to go out and seek someone to do this? I mean, I'm comfortable with it, Sudbury Valley, personally. I mean, we've worked with them. I don't see any issue. But is there a requirement that we have to do something else before we accept any proposal? Do we have to advertise? I really don't know the process.
mean
Public
like
of-
bidding almost, like an
No,
RFP?
no, not
Yeah.
bidding, but do we have to say the town has a parcel of land, we're looking for a management? We can just decide on our own. I don't know. I don't know what the process is. It's
And-
not a
and
trick
my
question.
question for asking is, I don't want there to be any perception to, I think, going along with your thought process, that, you know, an SVT may end up being the best, and we want the best. So, but I want to know what options the town, and I think the town has a responsibility to the taxpayers to ensure that we've done our due diligence and looked at whatever available options are out there, and then make the best decision for the town.
I'm on the same page with that, but I don't know what the process is. I guess I'm looking to find out, is there a process that we have to follow regardless of the decision we make to get us to the end?
Well, I don't know that there's any formal RFP-style process.
That's fine.
We'll check that. I don't think there is.
All right.
You know, so far, all we've discussed is our own local land foundation, which respectfully does not have the necessary resources, and SVT. So we would take any direction to investigate any other land foundation. I mean, we're not at the position of recommending somebody, but if the board was considering any specifics, or if you didn't, then we would, I guess, go out and find somebody as qualified, if that's your direction.
In part of that line of questioning may be, in negotiating this, do you have to pick one, and then you're left with negotiating with that particular one? Or this happens all the time in my world, there are people that are negotiating at the same time with different entities, and who's gonna provide the very best deal at the very best price to the town?
Sure. So I'll just sort of chime in here to say that there are many qualified land trusts across the Commonwealth that hold conservation restrictions, or could. Very often, they are local land trusts. So, as town council mentioned, here in Southborough, you have the Southborough Urban Land Foundation. We've already know that that's been explored and isn't going to work out. They do really, those smaller local land trusts really do tend to focus on 1 or 2 municipalities though, so by and large, those wouldn't really be good options here. The next level is more of sort of a regional land trust, which Sudbury Valley trustees, certainly I would put in that category. The Greater Worcester Land Trust is another one in this neck of the woods that would be an option. And then there's also sort of statewide land trusts, Audubon, Trustees of Reservations, Mount Grace Land, I'm forgetting exactly what that, but Mount Grace. So there are a number of them. My perspective, my opinion is that in Sudbury Valley trustees, you have an excellent land trust, highly respected, very well known. To answer your question, in this particular setting, I've never really seen nor heard of a situation where you had a property owner, the grantor essentially, kind of shopping between, or not even shopping, but kind of playing grantees against themselves, kind of trying to get leverage almost in a negotiation setting. Really, it's always that you find a grantee, a land trust that's qualified, that makes sense, that works, that's willing to accept the grant of a conservation restriction, and then you work with that one entity moving forward. Now, it might be that very early in the process, you find that that particular land trust is going to require an endowment, say, that is far greater than what you as a property owner are willing or maybe even able to pay. And at that point, you'd probably go look elsewhere. But once you've identified and selected the trust, at that point, you're, I think, pretty well locked in my experience, mainly because these land trusts are charitable organizations. They don't have infinite resources, so they're not going to be interested in participating in the back and forth that goes into the drafting on one of these CRs if they don't feel confident that they will ultimately hold that CR. So I guess to answer your question, if you did want to look for other land trusts that might work, I would suggest that that needs to happen immediately. And, again, just from my perspective, my personal opinion, I think you've got really the top of the line in SVT. And I think more than anything, from my perspective, why that matters here, where we do have a really unique type of conservation restriction, and where we're going to go to EEA and ask them to approve a CR allowing continued operation of a golf course, which is not something they're accustomed to seeing. I do think that it would really be a benefit to have the grantee or one of the grantees be an entity like SVT, which is just really, really highly respected. No doubt about their qualifications. They're known, and I don't think EEA would second guess seeing SVT as one of the grantees, where a lesser-known land trust, there might be a higher level of scrutiny or some second guessing.
And then from your perspective, based on the discussion tonight and the vote to co-hold, do you think they would be receptive to that, or do we need to look at other entities that would be more receptive to a co-hold?
I saw a letter from SVT relatively recently indicating that they would agree to co-hold, that their preference would be to be the sole holder. But if I'm recalling correctly, they were willing to be a co-holder with the Conservation Commission.
Yes.
I'm sorry, if I may. I also agree it does the town a service for us to look to see what is the best for the town. But I thought, and I could be mistaken, I thought one of the things that was important through all the discussions that have been had is to have a locally held, that's why SOLF was our first choice, to have somebody locally held. I know SVT has land here within town and has relationships in town. I don't know so much that the others you mentioned through Worcester have that relationship that's already had here, and also where SVT has a relationship with the other land trust in town. I think it's very important that we take that into consideration as we decide which road to go. I could be mistaken, but I thought the direction was kind of clear. It was having a foothold, so to speak, I guess, in Southborough. And again, I don't speak for the rest of the board, but that's how I understood it to be. Thank you. But again, I would support SVT.
Yeah, and then maybe an option is if the board has a willingness to support SVT, that, that could be a vote, contingent upon, your understanding with them that they're receptive to this idea. And if they're not, obviously, well, then I guess we gotta come back anyway.
Yeah.
But, yeah, I just wanted to make sure at least it was discussed that, I don't wanna, have, only be looking at one entity when
Sure.
someone says to us afterwards, why, Board of Selectmen, didn't you look at these other three?
Sure.
So in your expert opinion, they would be the very best and they would be willing to do this?
Yeah, no doubt about, again, their qualifications, their reputation, their ability to do this. And it's my understanding that, yeah, I believe the board has voted and they've, voted to accept co-holding
Okay.
this CR.
I don't know if it's co-hold or if it was individually hold, but I will say that I know Krista not quite as well as Luke does, but Krista Collins, and I had an initial conversation with her, and then what elicited this letter was my inquiry about willingness to co-hold. And, she indicates that there are reservations here and the SVT has not voted it, but she went beyond that and discussed the concept of tiebreaker and memorandum of agreement, and I now know who their legal counsel is. So the framework is all set up that if that is the decision, we can move forward and start discussing that with them if you choose them.
Okay. Any other thoughts or suggestions?
Yeah, I
Mr.
mean,
Schifrin?
I think I am relatively new to the CR holding process, and it just seems like SVT was brought to us or included in this in the beginning with no other options. So if it's possible, I mean, at least I would like to see 2 or 3 other of those acceptable names that could go with it. And know, since there are negotiable parts of this CR, how they felt about it. The primary and secondary role of the co-holders. Do any of them have opinions as to who could fill the role? The restrictions on what the golf course manager is going to be able to do with and without permission. Is one going to be less restrictive than another? I just think if this board could see 2 or 3 options and how they feel, it would help in making an informed decision as opposed to just only really seeing SVT.
If we do have a meeting next Tuesday. If we had options provided to us from tomorrow before our next meeting, and we gave guidance to you, if that's the board's wish, is there a need for you to know tonight? Or if you knew next week, you have other work to do on this and?
We do have other work to do. The sooner that we know who the board prefers to hold it, the better will be to move this forward. I'm gonna start working on plans and move back into that avenue, and because we need those also.
And I'd be leaning towards SVT, but I'm with Mr. Schifrin. I think if the week is not gonna hurt us, I think it would be wise for us to understand what options the town has. Any other thoughts on that?
I see Sudbury Valley having a working relationship now with the town. Knows the town, knows where to go, who to see, who to call. I think we're just delaying this. I think we have a responsible trust that stepped forward that can more than handle this. So I'm in favor of Sudbury Valley.
Okay, other thoughts?
No, I'm in agreement with Sudbury Valley myself, and again, I think, for the reasons that Attorney Laguerre had mentioned, and again, because this is so unique where there is a golf course part of it, I think getting into these discussions with an entity that we have current relationships with, I think is going to best serve the town in negotiating this CR. So I'm ready personally to support SVT as the co-holder.
That sounds like a motion.
I move that we have SVT as the co-holder to the conservation
Is there a
restriction.
second, okay, for discussion? And I'll agree with Mr. Schifrin, but that I would have liked to have had other options, at least made available to us, and knowing that the week wasn't gonna hurt us. But seeing the, where the board is going on this, I think from what I'm hearing from council, that they are in a very reputable entity, I'll be in agreement, so. All right, it's been moved, seconded, all in favor?
Aye.
Aye.
Any opposed? Okay, 5-0. All right,
Excellent.
thank you. Okay. And I think that completes our work. Any other guidance you need from this board?
I have one more question on the CR. We received an email, I don't know when, from Mr. Boland regarding the CR and allowing the expanded use of, as an expansion of the cemetery.
Reserving the right, I think.
Yeah.
If I recall the email.
Was that ever acknowledged or addressed, or should it be?
The genesis of that might come from the fact that when we negotiated the Beals conservation restriction on adjoining land, there was a agreement that the town could make an offer at market value some years down the line on property that's on the west end of town. We never addressed that because I don't recall that that was any part of any of the general discussion of the town meeting or the town boards about any kind of a future use to that property. If that's what what he means, to convert a portion of the golf course parcel to a cemetery?
I
Is that
think
what
he
was
meant if
trying
there
to
was
say?
expansion required, if the town had to expand, decades from now, is that something that would be smart to at least reserve?
I think it's the assumption that golf wasn't there,
Yeah.
Golf wasn't there.
and there was a need, should it be allowable?
Or at least reserved as,
Well, so my initial reaction, and I'm certainly happy to think about this a little more if it's a direction that the board's interested in following up on, but while we were drafting this with the golf course CR committee, there was a discussion about reserving the right for agricultural use down the line. Should the use of as a golf course cease, using this for agricultural purposes? And I really opposed that, and I pushed back probably harder than I did on just about anything else I heard during the course of those hearings, because it's just, it's an example that I think is similar to using the property as a cemetery, which is not something that's typically allowed under a CR. It really is, even though you wouldn't think of a cemetery necessarily as being more of an active use, it really would be. And I think you're just adding a level of complexity and complicating this already complex and complicated document unnecessarily. So that my preference, I think, would be to not do that. But again, if the board feels strongly that that's something that makes sense for the town moving forward, we could certainly look at trying to incorporate that into the document.
I don't have a strong preference on it.
Yeah, personally, I think that unnecessarily complicates the
That's-
issue at this stage of the game, and I'm all in favor of a future Board of Selectmen trying to amend the CR. When they're looking for a place to bury me, but that's not, I'm not ready to take that up now.
All right. All right, any other thoughts?
I did receive that email from Mr. Boland, and he did suggest flat headstones. But I think what he left out, what I consider the most important thing, if we did develop it as a cemetery, you also have road work. There's, you're really, it may be flat, but with the roads and everything else, I don't think that's what the intention was with saving this property. So I would not be in favor of.
Okay. Anything else you need from us, counselors?
I think we
All right.
have our direction.
All right, you do, and thank you for your efforts thus far. We look forward to more of it. All right,
Thank you.
Donald.
Thank you.
All right, thank you all. It's our only discussion point for tonight. If there is any public comment, we've had plenty on this topic.
Yes, from me.
Seeing none, we will move to adjourn.
Here was, okay.
Second?
It was sitting in front of me.
All in favor?
Aye.
Aye.